There we go.
All right. Now already on best behavior. So we'll call the meeting to order. Welcome everybody here, and welcome Jeff Bridges to take notes for Lorianne while she recuperates from her broken hand. We ended last meeting, just getting in. Oh, and I should say thank you, Amy, for those notes on our previous meeting. Those were really helpful to kind of refresh where we were, because it's been a while since we have met. I don't think we need to go back and revisit any of that. Those are things that we will come back to, the ones that we've left up in the air anyway, that we'll come back to just in the natural course of things. But let's go ahead and start with section 5. And I'll sort of explain to those of you who are looking at the LC draft that Lori prepared. Section 5, what Lori has done, and she can speak for herself, but I'll just jump in. In the Uniform Act, there are brackets in several parts of Section 5. And the intent of the brackets is to leave it to the states to choose to permit or not permit electronic witnessing, basically. And so what you see before you, and Lorraine, you can confirm, I think I'm right. I compared the Uniform Act to this draft here a little bit ago. What you've got here is sort of the full meal deal of the Electronic Wills Act, that includes the language, what would be bracketed language in the Uniform Act, so that we have, in this version of Section 5, we are authorizing, just for drafting purposes, the remote witnessing of electronic wills. Otherwise, if you know, and that's a policy decision. Once we make that, all the drafting just derives straight from that decision. We can adopt this in such a way that we don't authorize remote witnessing, in which case I guess the way an electronic will gets done is everyone stands around the testator's computer or something, and they watch the testator make the will, and then they do what they need to sign it electronically, and that's the extent of the electronic will. Otherwise, if we go further than that, we allow the remote witnessing, and that incorporates then later in Section 8 the requirement of an immediate execution of a affidavit of a testing witness that can also be done remotely using our Remote Notarization Act if we allow remote witnessing. Lorianne, have I explained that about right?
Yeah. Yes. I also was looking through. We kind of went through our ORS 112-255 requirements.
Yeah.
And the Section 5 to highlight some of the differences. There are some slight differences that, if regardless of whether we allow the electronic witnessing, right, I think we'll want to make some of these a little consistent.
Yeah.
Unless it's intentional for
right.
the inconsistency. So
yeah, no, yeah, I agree with that. Just kind of like what we decided last time, to the extent that this appears to replicate, at least in the intent is of the act is, so we're replicating just sort of standard will provisions. I think we want to make sure that we're uniform within our own statutes between electronic and paper wills, where we don't have to be different. So let's have this discussion about requiring, limiting the act to electronic wills that are signed in the physical presence of the testator and two witnesses, I should say. Or for the work group, how do we feel about diving in on the electronic presence for witnesses? I'll invite anyone to speak up.
I'd like to hear from Victoria, if she's on, about how the May Uniform Laws Committee talked about this issue.
I don't see Victoria. Victoria, are you here? Yeah.
Victoria was one of the people who just sent the decline.
Okay.
I would
So-
just say that when we talked about this in the probate modernization committee, this was probably the most controversial issue.
Yeah. Of course, that was 5 years ago, and technology has moved on since then. And we also have remote notarization. Yeah, so Heather, I agree with that. I guess that's the question. Do we feel like we're ready? Oh, okay. Andrea wants us to reintroduce ourselves. Yeah, okay. It's a small group.
We speak.
So,
Just as we
huh?
speak. Blaine, just as we speak, we don't need to go around the
Oh,
room. But if
okay.
people just typing in for the first time, if we could remind their context. And I'm Andrea Meyer, AARP.
Okay, great. And that was Heather Gilmore, lawyer in Salem and a member of the estate planning section. So yeah, so I guess that's the question now in 2025. Are we ready to do what we weren't ready to do 5 or 6 or 7 years ago and actually make the recommendation to authorize the remote execution or witnessing of an electronic will? Matt. And then Teresa.
Matt Trump, Department of Justice. I do a fair amount of work in probate cases. So when I looked through, at the very least, it's not clear to me, and maybe this legislation is not providing for what this electronic document ends up looking like. It didn't appear to me, for example, that it requires the use of specialized software that would prevent alterations of the document after it's been signed. And I have great fear about the potential for fraud. I represent the state treasurer to administer the estates of people who've died with no wills and no heirs, and we have had cases where a purported will comes to light, has many hallmarks of potentially being fraudulent, and if a Word document that includes an S/signature is sufficient to satisfy the statutory language here that we're talking about, I would have very great concern about that. And so I could maybe use some education on if there is something that I'm missing, but just as a general matter, I have great hesitancy about the idea.
Okay. Let me get Teresa, you were in line.
Hi, Teresa Hollis. I guess I would love for someone to describe what the scene looks like when someone is creating this electronic will and it's remotely witnessed, because I can't quite picture how it would work.
Anybody want to volunteer that? I think someone maybe with experience, if you have with remote notarization, because I think the setup would look a lot like that.
This is Heather Gilmore, and I sat on the Uniform Laws Commission for remote notarization.
Yeah.
In remote notarization, in order to notarize, you make an appointment with the notary. And when you log on to the platform that supports remote notarization, which it's actually a platform, it is not, you can just kind of Zoom notarize. It's a specialized platform. It requires triple factor identification, meaning that the person whose signature is to be notarized has to upload appropriate picture ID. The person whose signature is to be notarized has to answer questions like, what color of car did you own in 1987? Those are the kinds of things that it does in order to properly identify the person. So there's some additional safeguards that go with remote online notarization that I'm not sure how that would look with remote wills. And then After the notary notarizes the signature, and the document is actually uploaded that the notary is going to notarize along with the ID, and the entire process of the notarization is video recorded. So you have some idea, like, was it an elderly person and somebody was prompting them? And often the notaries on their own inquire. It's kind of one of the things that they teach on their remote online notarization platform certifications. Who's there with you? You know, those are some of the protections that there are. So those things in remote notarization, I think, are as good or better than taking a document to the UPS store and having the 19-year-old clerk notarize your signature. So that's what happens with remote notarization.
And I would say too, I mentioned Section 8 before, it kind of plays into this. The Uniform Act requires that if you're going to make your will self-proving, the affidavit of attesting witnesses of an electronic will has to be made simultaneously, that is at the same time as the will. And so what Heather just described in the way of the remote notarization, I assume, would incorporate the execution of the will itself.
Yes,
And I
but
guess
that
Matt,
would, sorry, it would apply to the witness, not to
Yeah.
the testator.
right. But again, that has to happen immediately as part of the same transaction.
But couldn't the witness have a notary? Let's say there's two witnesses in two different locations. They could each have a notary there potentially.
Right.
Would that work? I just can't picture how it's actually working. And I know Jeff has his hand up, so maybe
Yeah.
he can answer.
Let's
that
go ahead,
question.
Jeff. Yeah.
Oh, you're
Turn on your mic, Jeff.
Yeah, I was muted.
Yep.
I raise my hand more to echo Matt's concerns with what the actual will looks like. From the court's perspective, we're supposed to be collecting the original will, and I'm not really sure what an electronic original looks like or how to distinguish that from other facsimiles or copies of the electronic. I mean, there's also serious questions about how the court receives an original electronic and what that would look like with the software we're sort of tied to for the foreseeable future. But that's a secondary question, is just sort of what is this thing that's being presented?
Okay. Who else? It sounds to me like these are questions more than objections. And I'm thinking as we before I go on, Tara, go ahead. Please introduce yourself. Tara. We're not hearing you.
She did say she was in the car, so maybe she's having some problem.
Oh, yeah, she did, didn't she? What I was going to say is, it sounds to me like this would. Oh, Tara, are you with us again? This may be an opportunity for us to invite someone from a state that has adopted the act with remote witnessing. Probably someone from the courts. No, certainly someone from the courts, as well as a practitioner who's experienced in it. And Amy, I'll bet we could get those folks for the next meeting. And I think, Heather, you may recall, it seems to me that when the remote notarization group saw sort of the demonstration, the scales fell from everyone's eyes, and they saw, like you mentioned, just how it works. Now, I will say, in looking at I've got the Uniform Act pulled up on my screen, and what it says here is this is a comment on to the Uniform Act that's on the ULC website. It says, because electronic wills may be executed via the internet, the question arises whether the witnesses to the testator's signature must be in the physical presence of the testator, or whether electronic presence, such as via a webcam and microphone, will suffice. Some online providers of wills offer remote witnessing as a service. The E-Wills Act does not include additional requirements for electronic wills executed with remote witnesses, but Section 8 imposes additional requirements before a will executed with remote witnesses can be considered self-proving. So it was, I think, intentionally not, the act was not tied to any particular technology or process. So that seems to be where the ULC work group landed. Who else? And I'm wondering, I mean, I hate to give everyone free time today, but I think this is probably a decision we need to make before we can do a lot going forward. I'm wondering if we ought to just call a pause here for this meeting. And we're missing several people anyway. And see, Amy, if we can get some people from states that have adopted this for our next meeting and have them answer some of these questions. Tara, are you able to speak now?
I think so, for a little while anyway.
Yeah.
Sorry about that. I kept
Go ahead.
dropping. And I missed a lot, so this may have already been mentioned. But I'm wondering if we have all this structure and all these rules for remote notarization. I would think that the same concerns about the document being notarized those concerns would be the same. And if we couldn't piggyback on those remote notarization rules to resolve the concerns about fraud in this case.
Yeah.
Just a thought.
No, it is a good thought. And I think another good reason maybe to hear from a state that has adopted this to see how they're addressing things. And I'm sure that's a concern that any practitioners would have and any court system would have, protecting against fraud. And this has been and is becoming more widely adopted. So I've got to believe that somebody else has invented that wheel. Well, folks, how do you feel about just taking it? Yeah, Andrea, go ahead.
All right, I'm trying to find the hand. Lane, I agree. I think that is a marvelous idea to get those who've done this. I think just for folks with ARP, our perspective is both to make this easier on folks to be able to do their wills and at the same time ensure that there's a sufficient level of protection for fraud. Yep. Alas, I have a feeling the next meeting might be while I'm gone, but I look forward to watching the recording. My only question is, and it may be that these are the issues covered, was there anything left in sections 8, 9, 10, or 11, or 12 that we might have similar questions that we want to queue up for these people who've been doing this work to come present on?
Well, let's see. Section 6 is our harmless error, and I think Lorianne has drafted that correctly, that we just incorporate our own harmless error statute in that. Section 7 on revocation, and I'm looking ahead here, that looks pretty straightforward. There weren't any brackets in the Uniform Act there. Section 8 we talked about, and that really does relate to Section 5 to a good degree, and incorporates the Uniform Remote Notarization Act. Section 9 is certification of a paper copy. This goes partway to addressing Jeff Petty's. I'm sorry, was it Jeff? Who raised the question of the paper copy? Was that you, Jeff Petty? Yeah.
Matt and I both, I think, have some reservations about what it looks like.
Yeah, and this makes it permissive. It says an individual may create a certified copy. And there you have your paper copy, but it is, you're right, an electronic will not be the original electronic will not be a paper document. But again, some courts in other states have figured that out in order to make this act work. So I think that's probably subject to the same. So Andrew, I think that basically the question about that Matt and Jeff and others have raised here, I think really are the linchpin to the rest of the act. And I'm not too worried about taking a break right now. This is not a long act. It's not going to take us time to recoup here. And I think this is probably the single most important question, because it works either way. It works. Well, I guess even if we don't have remote witnessing, Jeff Petty's question is still the same. What do courts get in the way of an original document? So, yeah, we still need to answer that. But it won't be long and drawn out. For those of you who might have been part of the Parentage Act, it won't take us 3 years to get through this draft. So taking a short meeting today and coming back next time with our questions primed based on this discussion, I think would be really helpful. And we'll have more of our work group with us then too.
This is Heather Gilmore. Could we also invite Susan Gary? Because my recollection is in probate modernization, Susan had a great summary of all of the different approaches because there wasn't just one
It's true.
approach.
Yeah. Yes. And I want to say that Susan was the reporter on the Uniform Act. I'm just looking. Yes, she was. Let's get Susan in here. Susan Gary was the reporter on the Uniform Act. Those of you who don't know Susan, she's, I think, retired now, professor at University of Oregon Law School. So great resource and an excellent suggestion, Heather. So Amy will want to talk to Heather, and then I would suggest we reach out to ULC and
Yeah.
find out what states would be best to answer these questions. Who's dived in all the way,
Okay.
and how did they resolve these questions, and what's been their experience? Yeah, Matt Trump.
In the ledge concept, section 12 deals with how proposed amendment to ORS 112.238
Right.
is something we could potentially talk about today, or at least I can raise a
Okay.
question / concern about, which might also get answered by whoever we invite to the next meeting.
Please go ahead.
So 112.238 is the statute that allows a document that has not been properly executed to be submitted to the court, and the court can review and make a ruling that it
Right.
will be treated as a will. And so the proposed amendment would allow for a electronic will to be admitted through this process. And I guess I would have a concern that, again, for fraud, that if, you know, in my mind, I'm just envisioning somebody drafting up a Word document on the computer, and you get to the signature line and you put in /S, and you get to the signatures of the witnesses and you put in /S. And then you say, this is their will. They intended it to be their will. Yes, it was not properly executed under the electronic wills statutes, but court, we want you to admit it anyway. And if my first level concerns about fraud in creating electronic will can be potentially resolved through clarification that there's a good process in place, my second level concern is this seems like the back door that just leaves everything wide open, because we are saying that, okay, even if you don't use all those really good processes that confirm that this is a valid will, you could still submit it to the court and ask the court to admit it. And so I'd have also concern about whether we really want to invite that.
Jeff.
I just want to get on Matt's wagon with this one also. Having been a person who's reviewed 10,000 plus wills for admissibility and validity, this harmless error electronic will sounds like my personal hell.
Lorianne, the legislature did tweak the harmless error statute in this last session, didn't they? Are we looking at the updated?
It's got to be
No.
signed now.
Yeah, okay. I was going to say this isn't the updated version.
No,
There's
this is not the updated
So what?
version.
Yeah. What is different?
Actually, I have to say that I this is one of the things that I flagged in the language that's in the Electronic Wills Act as being better than the language that we just enacted.
Yeah.
So basically, it clarifies. Actually, I have it pulled up. Is there a way I can share my?
I can do a quick summary if you want. I helped draft the legislation. This is Heather.
Oh, yeah, go ahead.
There's 3 now harmless error applicable rules. The first one is pre January 1, 2026, which is going to be number 2 is it's currently before the Court of Appeals. And number 3 is post January 1, 2026. It has different requirements. So trying to draft around harmless error right now is going to be a bit of a trick because we don't know what the Court of Appeals is going to do with it.
Heather, what
And
is
it
that
has to
Court of
do.
Appeals case? Can you tell me that?
I'm sorry, I don't have it right in front of me. It's essentially the question of at what point in time does the writing have to be signed? Does it have to be signed before the Harmless Error Act went into effect or after the Harmless Error Act went into effect? And I don't have a site. I can get one.
Yeah, if you could send me that, that'd be great. Is this the case that I think Brooks Cooper was working on? That it's, I feel like that came up during some conversations last session, but nobody told me what the case name was.
Yeah, I'll get you a case site. I'll just try to post it to the committee so that we can see it. And we couldn't fix the whole statute. The whole statute needs fixed, but there's a kind of unspoken rule that you don't fix stuff that's currently before the court. So we may need to come back and fix again, but
Well, Heather,
you know,
what's the rule for wills executed after January 1, 2026? Because
it
that
has
would
to be signed.
okay.
It has to be signed.
Okay, so that would apply going forward to the Electronic Wills Act, since those would all be done after January 1, 2026.
It has to be signed before the decedent's death, which is an awkward way of saying that if the will is being signed by somebody at the request of the decedent or the testator,
Yeah,
they have to do it before the testator dies. They can't say after the fact, after the testator dies, oh, they asked me to sign this on their behalf. Here's what I'm doing. I'm doing that now for them. And so it's phrased a little funnily in the Electronic Wills Act. It says that if it's being for the electronic will, if it's being signed at the testator's bequest, on their behalf, it has to be signed in that person's presence.
right. That's
like
true.
Contemporaneously. It can't be something you do later, which I think is kind of it makes more sense to say it that way than the way that it's written in Senate Bill 168 that just went into, will become law in January, is that the writing has to be executed before the decedent's death, and it either has to be signed by the decedent or at the direction of the decedent, another person signed the decedent's name and the signer's own name. So that's one of the things that I think that we should try to make consistent between the two things.
Okay.
Provisions when we get
there. And maybe in this case, using the uniform language to update Oregon language.
It does. It is an extra step, a little bit more of a requirement than what's in Oregon law currently. So currently, we don't require that the person signing at the testator's request be there with them signing. So that's a policy call, whether to restrict that ability a little bit more, but I'm sure people have thoughts.
So I don't know that we need to answer that today, and I think although honestly I'm kind of taken with that, but we'll get to that. But if that probably still doesn't satisfy all of your concerns, Jeff, I'm guessing, or Matt.
I'm going to be on Jeff. This is Heather. I'm going to be on Jeff and Matt's bandwagon.
Okay.
And if we decide that we can do all of these things remotely, my my jump on the bandwagon would be to have harmless error not available to electronic wills.
That's another option.
Yeah, just because, boy, I can think a lot of ways I could fix that if I wanted to take money.
Okay, but you know that let's add that to the list of questions for Susan, Gary, and whoever our representatives are from the other states that have adopted this.
And right now, sorry, Lane, just
Yeah.
one of the other changes that Senate Bill 168 made to
Uh-huh.
the harmless error doctrine is to say that it does not apply to electronic documents.
So we would have to go back on that.
Mhm.
Yeah. Okay. All right, Amy, that sounds like a good list of questions for our panel of experts. And let's see, what's our next meeting date? We have it set already.
We do. It is, so I actually wanted to talk about that.
Right.
Because I said something incorrect.
Yeah, we have October to figure out.
Yeah, October to figure out. So our September meeting is September 26th,
Right.
at noon on a Friday.
Yep.
So go ahead.
I was
And
going to
we-
say, yeah, let's on that one. Let's go ahead and see if we can get Susan available for that, as well as representatives from one or two of the other states that have adopted to answer these questions for us. That'll be September, but then October we have a date mix up that we need to settle today.
Yeah. So as you probably all saw, I sent out an email saying, hey, we're going to meet on October 31st, but then the calendar invite said October 24th. I apologize for that. That was a boo-boo on my part. So I'm happy to go either way. Lane, I don't know if there's Lane and Eric, I don't know if there's or Lorianne as well, if there's something that works better for either one of you. And Teresa, thank you very much for pointing it out, because you were the one who sent me the note being like, hey, wait a second.
I saw that.
So thank you for that.
Well, actually, neither October date works for me because I'll be out of the country for about 3 weeks during that period, but we should have the work group meeting anyway. I mean, this group is fully capable of having a good meeting without me. So I don't care. Well, you know, actually, who knows? If there's internet on the ship in the harbor in Bangkok, maybe I can join in at noon here on the 31st. So I will put it on my calendar just in case. But yeah, folks, do we want to go 24 or 31 in October? Tara says the 24th.
I think
That's
probably works better. So
it's a little bit more in keeping with the cadence of the meetings too, I think.
the
All right, do you want to
24th.
send? Yeah. So is that the invite that you sent out? So are we already good, or do you want to just send maybe a confirming invite and email?
I will do two things. I will send out a confirming email that it's the 24th. I will update the website because
Okay.
the website right now says the 31st,
Okay.
and the calendar invite is correct. We'll
Okay.
just stick
All
with
right.
the 24th.
Very good. All right, so here's what we're gonna do. We'll stop for today. You're welcome. And you know, if you have questions, practical questions about this notion of remote witnessing and how the harmless error statute works with electronic wills that have been generally. I would say, please send those to Amy, maybe with a CC to me, and we can put those out in advance to our guests for the next time that we're able to get together, so that they've had opportunity to kind of give us get a thoughtful answer prepared for that, and I think it'd be an excellent discussion. And I'll say myself, I don't have a huge investment here either way, so I'm kind of just interested to see how this goes in the conversation. All right, everybody? Yeah.
Just a quick thing. So my goal is to send out the agenda 2 weeks before the meeting. So if you do have something, and I'll send an email out on Monday for the people who weren't able to attend today. If you do have something to add, just let me know before 2 weeks before the 22nd. So
Okay.
that's early September.
And then Amy, do you want to go ahead and get in touch with Ben or whoever it is, whoever the staff person is
absolutely.
in Chicago, and have them help us identify the right
Absolutely.
people in the states that have adopted?
Yeah.
Okay.
Happy to do that.
All right. Thanks, everybody. Have a great weekend. Oh, stay indoors. Don't do the Hood to Coast relay this weekend in case you, it's too late. You're either on it or you're not. Man, can you imagine that though? All right. See you all. Take care.
Thank you.
Bye.